morning. Thank you for joining us again. And thank you for coming to this morning's opening session. My name is Hannah Lussman. I am a 2L at KUI. I am a first-year staff editor on the Journal, and I am also the outreach chair of KU Women in Law, and KU Women in Law is a co-sponsor of today's event. And I'm really excited to be the moderator of the next panel. Actually has kind of a two-in-one presentation for you all. So first, we're going to hear the presentation in defense of victim impact statements given by Professor Paul Cassell. He is the Ronald M. Boyce Presidential Professor of Criminal Law and Distinguished University Professor of Law at the S.J. Quinney School of Law at the University of Utah. Professor Cassell received a BA from Stanford University, and he then graduated Order of the Play from Stanford Law in 1984. He served as the president of Stanford Law Review while he was there. From 1984 to 85, he clerked for then Judge Antonin Scalia while Scalia was on the U.S. Court of Appeals for the D.C. Circuit, and the following year for Chief Justice Warren E. Burger on the U.S. Supreme Court. From 1986 to 1988, Professor Cassell served as an Associate Deputy Attorney General in the United States Department of Justice. From 1988 to 1991, he served as an Assistant U.S. Attorney in the Eastern District of Virginia, prosecuting many felony cases. In 1992, Professor Cassell began teaching at the S.J. Quinney School of Law, publishing widely in leading academic journals on crime victims and other criminal justice issues. He has filed briefs and orally argued on behalf of crime victims and allied organizations in the United States Supreme Court and other federal and state courts around the country. In 2002, Professor Cassell was confirmed by the U.S. Senate to serve as a U.S. District Court judge for the District of Utah, a position held until he resigned in 2007 to return to law teaching. While in the District Court, Professor Cassell had many opinions that attracted significant attention, including several on crime victims' rights issues. Professor Cassell currently teaches crime victims' rights, criminal law, and other courses at the College of Law at the University of Utah. Along with Doug Maloof and Steve Twist, he is the co-author of Victims in Criminal Procedure, the only law school casebook on victims' rights. He also represents crime victims and crime victims organizations on a pro bono basis in cases around the country, and as a tie-in to some of the comments we received in our last session, we want to mention that Professor Cassell is also one of two attorneys currently representing victims in the Jeffrey Epstein case. He has testified several times before congressional committees on crime victims' rights issues, as well as before legislative committees in Utah, Wisconsin, Nevada, and Idaho. Professor Cassell maintains an active pro bono practice. As we mentioned, in 2004, he argued for a crime victim in the United States Supreme Court in Caroline v. United States of Amy. The case involved the question of how restitution for crime victims of child pornography crimes should be awarded. This was the first time that a crime victim had appeared before the United States Supreme Court to protect her own rights in a criminal case filed by a prosecutor. So, without further ado, Professor Cassell.
Thank you. It's an honor to be invited out here to speak, and it's particularly an honor to speak after our last panel. We heard from Judge Aquilina, we heard from Trinae, a victim, one of many victims obviously in the case, and so I hope you won't think that I'm just pandering if I go to the next slide, which is, I guess that's one way to curry favor, is praise the previous speakers, I should say, both Judge Aquilina and, of course, the heroic victims that spoke at the sentencing of Mr. Naster. But I hasten to add very quickly that I'm not a Johnny-come-lately to defending Judge Aquilina when she was conducting the sentencing procedure about a year ago. There were some critics of the approach. There were those who said she's not behaving properly and so forth. And so this is what I wrote at the time for a blog that I'm a part of. I was very much in support of what Judge Aquilina was doing. I thought that the victim spoke eloquently and emotionally about what was going on. And I thought there were a few legal commentators carping, I don't know, I was trying to figure out the right verb to throw in there, and that seemed to me like what was going on. And I think it was also fair to say that it was uninformed carping. So let me spend just a few moments talking about what Judge Aquilina did to facilitate the victims in that case. Because I think those who say that that was somehow outside the judicial role, corruption of our criminal justice process or whatever it might be, don't fully understand the way the criminal justice process operates, certainly the way it operates in this day and age in 2019. So let's talk just a little bit about what the critics were saying back a year ago. She shouldn't have been talking about a death warrant. The law should be motionless and precise, and she's a judge, not a vigilante, we're told. Others didn't take to a meme to attack her. Others went to advance claims that she was violating the rules in various publications. So we heard in some journal that a defense attorney thought, look, she's championing victims here. It's understandable to feel empathy for voiceless victims, especially ones whose testimony took such bravery, but she was traversing the lines between just being a judge and converting herself into an advocate. Time magazine had another defense attorney who said this was a departure from the judicial role. A judge who reframes the sentence she selects as an expression of disgust has changed the task that she was assigned. And so I guess it's interesting. I think momentarily we can try to figure out what task was Judge Aquilina assigned when she was sentencing Mr. Nassar. The New Republic said, wow, to her discredit, she abdicated her role as an impartial arbitrator and instead became a tribune for prosecutors and victims, showing hostility and anger towards Nassar. So these were the arguments that were advanced, and as a lawyer, someone who's, and a former judge, someone who's looked at the judicial role, and I think I've tried to spend a lot of time writing and thinking about how do victims fit into our criminal justice process. Let's try to dissect some of these criticisms, because if Judge Aquilina's approach is going to spread to other courtrooms, as I hope it will, then we need to understand whether it's a proper rule or consistent with the existing legal rules. So let's start to take a look at some of the existing legal rules and try to figure out what those rules are. One rule that I think was not often mentioned at the time was that this was not simply a matter at some level of Judge Aquilina's discretion. To the contrary, Trine and other victims had in Michigan a constitutional right to make a statement to the court at sentencing. And so what we were seeing, I think this is important to understand, some judges might have been able to say, we heard reference to a judge in 1975 or something. Back in that day, perhaps a judge could say, I am too busy, I have other things going on in my life or in my courtroom, and I'm not going to take any time from victims. That is no longer possible in the state of Michigan. That's no longer possible in the state of Kansas, for example, where you have a constitutional amendment protecting the right of victims to speak at sentencing. And many states around the country have those constitutional amendments. I'm pleased to say that they are expanding. Just in the last election cycle, 6 additional states improved their state constitutional amendments, adopting so-called Marsy's laws to protect crime victims' rights in states such as Florida or Oklahoma, Nevada, and others around the country. So what we were seeing was not, I think, something that was just an option. I think we were seeing at some level something that was a state constitutional right. Now, when the victims were speaking to Judge Aquilina, is that unusual? Well, here again, Judge Aquilina operates in the state of Michigan, so I did a little research, tried to figure out what the rules were that she was supposedly transgressing. And what I discovered from the Michigan Court of Appeals was that there is not judicial bias that develops when a judge starts to hear information from victims, even if the allegation is that this is some inflammatory or marginally relevant prejudicial statements. To the contrary, Michigan law recognizes and I would say demands that judges hear from victims because the impact of a crime on a victim is a valid sentencing consideration. The Crime Victims' Rights Act, the statutory implementation scheme for victims' rights in Michigan, makes this a requirement. And so for a judge to consider this is not somehow prejudice or bias that's deflecting from making an appropriate decision. To the contrary, it's part of making an appropriate decision. So the rules in Michigan require that judges hear from victims. Well, what happens then once a judge hears from victims? Are we to have judges who are not humans? This is a case out of my home state of Utah, but I would submit that the principles recognized here apply in Michigan and elsewhere. We certainly expect judges to be dignified and courteous to the participants in the proceedings, but that does not mean that judges cannot, like other human beings, somehow become angry when they hear exactly what has happened in a particular case. And in this case out of Utah, I'm familiar with this case in particular because this is, I'm proud to say, one of my former students who went on to become a judge. He had a case in which a father was sexually abusing his daughter and trying to rationalize it, was explaining that this was doing her a favor or something like that. And so, in the course of those proceedings, the judge became angry. Well, that's, no law requires that. And by the way, do we want judges who aren't human beings? I mean, it's easy to say, don't get mad at Dr. Nasser, but there are going to be other cases where judges may have sympathy for defendants or sympathy for the community. I mean, we want our judges to be drawn from our communities, reflecting our communities, expressing the values of our communities, and that means, I guess at the end of the day, that we want human beings being judges. We can, I suppose, with the new artificial intelligence crusade that's coming along, we could replace Judge Aquilina with, you know, Big Blue or whatever the IBM computer is, and perhaps that would be viewed as progress or modernization, but certainly no law requires it, and I would submit that we actually wouldn't want that kind of a justice system. So judges may have human reactions. Judges may then form opinions, and here again, let me just throw out an authority. This one is from the United States Supreme Court. It may be the case the United States Supreme Court recognized that after hearing an entire presentation of what happened, the judge may end up being, and our U.S. Supreme Court always writes in, but the judge might be exceedingly ill-disposed towards the defendant. Was been shown to be a thoroughly reprehensible person. However, that does not somehow disqualify the judge, and that is not something that should be expected as unusual. Impartiality is not gullibility. Disinterestedness does not mean childlike innocence. If the judge did not form opinions about the actors in those courthouse dramas we call trials, and I would submit sentencings are similar dramas, he or she could never render decisions. And so, again, if the claim is somehow that a judge forming an opinion is a transgression of ordinary rules, no less an authority than our United States Supreme Court would dispute that view. Judges may then express opinions. And here's a case again from Judge Aquilina's jurisdiction, her appellate court. Her bosses, I guess in some sense, have said that sentencing is a time for comments against felonious antisocial behavior, recounted and unraveled before the eyes of the sentencer. At this critical stage, the law is vindicated, the grievance of society and victims is redressed, and the language of punishment need not be tepid. Once again, our appellate court speaking cautiously and carefully. Judge Aquilina perhaps speaking a bit more directly. But again, if the rules are what we expect our judges to follow, the rules are that the judges may express opinions, indeed, at some level are expected to express opinions to vindicate the law, to address grievances, and to redress victims. So I find nothing wrong with what happened during the proceedings. Can judges express sympathy for victims? We were told that that was somehow inappropriate. And here again, just to show that these principles are shared across the country and aren't confined to the state of Michigan, this is a case in Nevada. A domestic violence victim expressed how she was harmed by the terrible crime committed by the defendant, the different effects that you can see there that she had. The judge then trying to, I guess, engage in restorative justice practices, advised the victim to put this matter behind her, suggested that there might be an approach to facilitating her psychological healing, a religious leader, informed her that the defendant would be behind bars for a long time and therefore would not be in a position to do any further harm to her. The Nevada Court of Appeals saying these remarks were proper. They were made at the end of the victim impact statement during the sentencing process. So once again, the rules of the game, if the claim is somehow that this is not permitted, clearly the rules permit this to happen in our Nevada Court of Appeals. And so we see here a whole series of rules that I would submit support what I guess we're calling restorative justice practices as occurred in this particular case, all of which are recognized in these various court decisions. Now I think it's interesting to think about what happened in this particular case. I think Judge Aquilina has said that, this was perhaps not something that's followed everywhere. As she says here, I hope I've opened some doors. Maybe everybody ought to be doing this. So let's talk just a little bit about this. Should everyone be making greater use of victim impact statements? And now maybe I'll just switch gears just a little bit as an academic and try to say, all right, why do we allow victim impact statements into a criminal justice process? Indeed, why does the state of Michigan, the state of Kansas, my home state of Utah, the United States Congress in passing the Crime Victims' Rights Act, why do they create a right for victims to deliver a victim impact statement? And I've written an article called In Defense of Victim Impact Statements, some of which I'm recounting here today, where I try to make the claim that there are 4 compelling reasons for victim impact statements to be a part of our criminal justice process. And the first argument, or the first rationale, is that victim impact statements provide information to the sentencer. I was a judge for a while. I heard victim impact statements. And every time I heard a victim impact statement, I learned something new about crimes and their effects on victims and the far-reaching ripple effects that crimes can have that I didn't know before. And so if we're going to have a criminal justice system where judges, human beings, are imposing sentence, we want that sentence to reflect the harm that was committed. How better to learn what the parameters of the harm were than to hear directly from the victim. And this can change the sentence, or maybe not change the sentence. My impression is that Judge Aquilina's sentence was not going to be altered by whether Trenet had given an eloquent victim statement or not. That there were various things that were already in place that might have dictated the sentence he would give. So perhaps this particular sentencing proceeding isn't an illustration of sentences changing. And indeed, it's interesting. You sometimes hear the claim that if we let victims give victim impact statements, that's just going to increase the punishment that's imposed. The empirical evidence on that, frankly, is very mixed. It's not clear that victims lead to longer sentences. The one empirical finding that's out there is that victim impact statements tend to increase restitution, probably because victims are able to provide information to the judge about financial losses that they may have or additional needs that they may have. But other than that, it's not really clear that victim impact statements increase sentences. In fact, there may be some cases in which a victim impact statement might lead to a shorter sentence. I currently have an amicus brief that I worked on in front of the U.S. Supreme Court, trying to get the Supreme Court to grant certiorari on behalf of a criminal defendant who was sentenced to prison in federal court rather than maintained on work release, where he had a very well-paying job that could be used to provide additional restitution to victims. So there may be situations where the information that's provided to the sentencer could produce a shorter sentence. Although obviously there may be situations where it may produce a longer sentence. But neither of those are things to be concerned about. Those are simply a result of a process that provides additional information to the sentencer, be it a judge or a jury, so that an appropriate sentence can be imposed. Why else might we have victim impact statements? Well, I think there can be a strong argument made that victim impact statements benefit the victim, and we've already heard a little bit of discussion about that topic today. We've heard during the sentencing proceeding, those of you who followed it, great support from the victims, from Judge Aquilina. Here are a few of the quotes that she gave, and she made it a point, from what I can tell reviewing the transcript, of responding to each victim after they'd given their victim impact statement. I suppose that's one advantage of human beings over computers conducting these kinds of proceedings. So after one victim had spoken, "Push away the nightmares, he's gone, your words replace what he's done to you." She addressed another victim who was thinking about suicide. That should not be done, and you can see here, please stay with us, stay with your family, your children need you. We can only hope that those words have the desired effect, and we certainly, I think, want to have a system where those kinds of words of support can be provided to victims who are giving victim impact statements. This is, I think, one that becomes something of a meme and probably has produced more attention than just about any other quote. Go out and do your magnificent things. And hopefully, again, are we naive? Do we think that a few words in a courtroom are going to suddenly transform all of these women into completely cured, completely healed women that are going to go off and never have a second thought about what's happened to them? No. But will this make a difference? I submit that it would. Well, I was hearing the talk this morning too. It was interesting. We heard from Trinae, so I just thought it would be interesting to see what Judge Aquilina. This obviously wasn't scripted. This is what she said, having heard from Trinae just immediately after the event. And I won't take the time to read all of it for you. But I think you can see, and I think we heard from Trinae today, that having even these few words from the judge, someone who's an authority figure, someone who is viewed as a neutral arbitrator in these processes, can have a very traumatic effect. And so these are the kinds of things that can come out of victim impact statements. Again, I'm not trying to make some sweeping claim here that everyone who delivers a victim impact statement will suddenly and magically be transformed forever. It may also be the case, let's be clear, there were a number of victims who decided not to give a victim impact statement, or perhaps to give a victim impact statement in writing. That's simply a reflection of the fact that victims are individuals. But if this means that some victims are going to have a healing experience, or at least a somewhat healing experience going through the criminal justice process, certainly it seems to me that we ought to encourage that. Why else might we have victim impact statements? Well, I think an oftentimes overlooked potential benefit is that a victim impact statement may explain the crime's harm to the defendant, and perhaps the Nassar sentencing is a primary illustration of that point. You will recall that during the proceedings, Mr. Nassar indicated that he should be exempt from having to listen to the victims because it would be, quote, bad for his mental health, close quote. Judge Aquilina took what was the phrase, I kept a view of that, I think, was said, and said, no, I'm going to require you to listen. And so one of the things that was interesting, again, I pulled up the transcript of Trinae's victim impact statement, and it was interesting for me just to look at the first couple of sentences of that. Victims are sometimes unsure, can I talk to him? Do I have to talk to you? What do I do? And so this is kind of interesting to watch here what Trinae was thinking. If you will allow it, I would like to address him directly. And so at this point, I suppose, is when Trinae gives the statement that's been alluded to here today, having an opportunity to speak directly to Mr. Nassar. And at that point, that's apparently the one victim impact statement, reading the press account, that seems to have somehow penetrated the wall that was otherwise there and led to him crying, perhaps beginning a path to redemption. We can only hope, although whether that will or will not occur is not something that we need to spend a lot of time on here. But this is the statement that Trinae gave. And again, I think this is the kind of thing that we want our criminal justice system to encourage. This is not breaking the rules or something that we should take a dim view of. This is something that we should take a very positive view of. I think this provides another reason for having victim impact statements. And finally, one last reason why we might have victim impact statements. What did people think after this all happened? There was some carping from a few defense attorneys. But other than that, my sense was that the country, and indeed perhaps the world, applauded the sentencing proceeding that occurred in this particular case. Again, is that something that we should run away from? Oh no, the public liked it. I think all too often we think that, well, there must be something wrong with it. No, our criminal justice system is designed to express the will of the people, to address grievances, and to make people believe that there is in place a process for holding wrongdoers accountable and for producing a fair and just outcome at the end of the day. Was the process perceived as fairer as a result of the fact that more than 150 women were able to come forward and give a victim impact statement? I submit that it was. I submit that's part of the perceived fairness of sentencing, and again, something that we should be encouraging when we set up our criminal justice system. So these are the various rationales for victim impact statements. What kind of research do we have on victim impact statements to back up perhaps some of these claims? Here I'm going to put on the law professor hat for a moment, or the researcher hat for a moment, and indicate that, frankly, we have very limited research now about victim impact statements. I'd love to be able to support those 4 claims with more evidence than is available. There is, by the way, some evidence, empirical evidence, to support each of those 4 claims. But the truth is we have very few studies on this. A lot of research in the criminal justice process focuses on criminal defendants and on their rights. Other research focuses on prosecutors and deterrence and societal benefits, but the victims are oftentimes the odd man or odd person out. And so we have limited research on victim impact statements. And the focus of the existing research has often been, well, okay, if there's a victim impact statement, does the judge give a longer sentence or not? And there have been folks trying to research that question. As I say, the research on that is somewhat mixed. It isn't exactly clear what effects victims impact statements have in terms of sentencing severity or on jury severity if you're talking about capital cases, for example. It's also difficult to say very much about what a victim impact statement typically looks like. You know, we've all read examples. I was able to go on Google and find Trene's statement, and you know, you can find individual examples. But you know, what does a victim impact statement really look like? It varies from crime to crime and person to person. And so one of the things that I'm interested in doing is the research project that I'll be working on this summer. Can we use the Nassar sentencing as an area to learn more about victim impact statements and how they operate? Let's think about this. We have more than 150 victims, and while each victim was subjected to her own abuse, the abuse was in some ways similar from victim to victim. And so this might allow us to explore the question of, do victims who have experienced at least somewhat similar crimes deliver then somewhat similar victim impact statements? And let me just give you my working hypothesis in answer to that question. My working hypothesis is no, that the victim impact statements are going to be very different from victim to victim, individual to individual, and that they're all going to be unique and differentiated. And so that's one of the things, you know, that's again a research hypothesis. Maybe we'll find some common themes if we look at the various impact statements. But my guess is that we're going to find just a wide variety of things, which again is another reason to applaud victim impact statements. We oftentimes hear things like, well, the victim's view on this particular point, or the victim wants this. Well, you know, that may be true, but then again, when there are 150 victims, my suspicion is that there are 150 views on sentencing, all of which should be provided to the judge, and then the judge is, in our system, the one who could make the final decision. So here's what I'm working on, the various questions of interest that come up. I have collected the transcripts of, I think, about 150 of the victim impact statements that were given to Judge Aquilina. So like, how many decided to give oral statements? Some of this, I say, may not have felt up to the task to presenting something in front of the courtroom or in front of the defendant. It might be interesting to see were there some who chose not to give oral impact statements. Were these statements always delivered personally? In my impression, sometimes that a representative of the victim might speak, a parent or a friend or an attorney. Sometimes, many of the statements in this case were delivered personally. How long were these statements? You know, we hear, oh, this is going to take forever or whatever. I mean, it was, to me, we had 150 statements in 7 days. I mean, that doesn't seem to me like it takes, that's a lot of victims, but not a lot of time per victim. And it would be interesting to see if we could measure this by the number of words. How long is a typical victim impact statement? And as a society, are we ready to spend, I don't know, 10 minutes a day, 10 minutes for a victim to listen to what they have to say? I would submit the answer to that question is yes, but it would be interesting to at least have some understanding of how long are these statements typically. Do they reference what I would call the healing process or the therapeutic qualities of delivering a victim impact statement? Some of the victims, I think, may have said that, some of them may not. It would be, again, interesting to hear the voice of the victim on this particular issue. Do they reference forgiveness, and are they positive or negative? And again, my suspicion on this would be that we're going to see answers all over the board on this. Some will be very forgiving, some will be very unforgiving. And again, that's not something to say, well, this is the right answer and this is the wrong answer. The point is simply that victims may have their own unique voices to add on these kinds of questions. And do they include extraneous material? What sorts of things do they add in addition to talking about the particular case? What else might we want to look at? Is there an effort to describe the impact of the crime or the harm for the crime? As I mentioned, I think that's one of the first and most important sentences or purposes of a victim impact statement. And so it would be interesting to see whether these impact statements provide some information about the impact of the defendant's crimes. Do they provide that information to Judge Aquilina? It would probably be hard to tell. This might be a little bit of a judgment call. Do they provide this to others? universities or athletic organizations or others who might have been culpable in some way in the crime? Do they describe the abuse generally? Do they describe particular acts? How is that done? Again, I think these are all important questions. Do they make specific sentencing recommendations to the judge? My suspicion here is that that didn't happen very often, but I believe that was because of the way the process in this particular case was set up. There are many other cases, of course, where victim impact statements are presented to a judge who might have options ranging from probation to life in prison, and so maybe this particular project isn't the best way to get a handle on this point. But it is interesting to think about whether victims want to provide specific outcomes to the judge, or whether they want to provide information which the judge can then use to reach an outcome. Do they directly address the defendant? And again, it would be interesting to see. We know that Quinney was an example of that. Maybe there were others who addressed the judge, or maybe there were others who were addressing a different audience. What type of address do they make? Is this a personal attack? Is it an effort to show to the defendant the consequences of the crime? Is there a request for restitution? These are all things that I think would be interesting to look at. Although again, some of these things like restitution may not have been a very viable option given the parameters that existed on this case. What kinds of restitution and so forth, also of interest. All right, is there a reference to general deterrence? You know, send a message, not just to Mr. Nasser, but to others who might be thinking about this. Is there a reference to other victims, and what kinds of references? Is there a reference or a shout out, a thank you to prosecutors or victim witness coordinators, members of the prosecution team? What about to therapists or mental health professionals who may be involved? Reference to family members who have supported victims. These are all questions that I think would be interesting to look at, so that we could understand better what victims are doing. So what I put together is this data collection instrument, and I'm going to, with some research assistants, try to go through, and on each of those questions I have various boxes, you know, that could be checked as to what was going on, to try to get some understanding of what we see in these things we call victim impact statements. And so I'll use one of the reasons I wanted to come out to this conference is some of you are very knowledgeable both about the particulars of this case or about victim impact statements in general, so I'm requesting your help. Should I be exploring anything else? I just gave you the general subjects that I was going to be looking at in the course of the project. How can I, you know, if we're trying to say, you know, was this addressed to the defendant or addressed to the judge or addressed to other organizations? How do we figure that out? How can we tabulate that? I don't know. One of the difficulties, obviously, is that this isn't going to be like deciding whether there are two oxygen molecules and a hydrogen molecule. This is going to involve some subjectivity and qualitative assessment, and so it would be interesting to figure that out because it would be nice to have some consistency from case to case. Should I be pursuing other approaches? Should I be interviewing the victims or trying to do something else? So if you have any thoughts on how this research could be pursued, I would appreciate it. All right. Well, let me now, I've said things that I suspect many of you will agree with, but let me now maybe raise a few cautionary notes, or at least notes that some of the other speakers may want to address. I know we'll be hearing from some other speakers today. And the point I want to make is this. I'm very much a fan of what went on during the criminal justice process in Michigan under the wise guidance of Judge Aquilina. But let's understand, this was all part of a criminal justice proceeding. Could we simply move that proceeding into a restorative justice proceeding? And here now we're going to start to get into a bit of a debate, I suppose, or at least a bit of a question. Well, what does it mean? I mean, maybe that was a restorative justice proceeding that Judge Aquilina herself was presiding over. What do we mean by restorative justice? And so, you know, again, if you try to find conventional accounts of what restorative justice is, here's a research article that's frequently cited. It's a process whereby all the parties with a stake in a particular offense come together to resolve collectively and how to deal with the aftermath of the offense and its implications for the future. And again, at some level, you can look at that and say, well, you know, who could be opposed to that? What does that mean? I guess my concern that I start to have is, again, I just popped Google, you know, for restorative justice, and this is one of the slides that pops up. I'm putting this up as a conventional account of restorative justice, and you'll see this interesting slide. It focuses on communities of care, reconciliation, victim reparation, offender responsibility, and by doing different intersections of the Venn diagram, you can come up with processes that are partly restorative, mostly restorative, fully restorative. The thing that was interesting to me is, as you look at this slide, which has, I know the print's a little bit small, it has a variety of different things in it. None of those things involve the criminal justice system. The criminal justice system is apparently not part of our conventional understanding of restorative justice. And so it's interesting, if it's not part of restorative justice, where is it? Or maybe this is an inaccurate account of restorative justice. It's interesting, we'll be hearing from Professor Cohn later on today. And she has written an interesting article about restorative justice, and there was a passage in that where she was trying to define restorative justice that I thought was worth highlighting. She mentioned some things about restorative justice, but she says restorative justice proponents seek to work outside or alongside traditional criminal and civil justice systems to achieve broader and more flexible resolution. I like that conception of the issue, and let me again make the argument that it should be alongside traditional criminal justice systems that we would have these restorative justice approaches such as Judge Aquilina, rather than as a substitute or outside the criminal justice system. And let me then just throw out a modest hypothesis. Again, I'm not necessarily subscribing to this, but I think it's all too easy at a conference on restorative justice to hear nothing but milk and cookies and how wonderful it is. But there are some cautionary notes that I want to raise. So my hypothesis, which I'll throw out because perhaps it will be shot down by subsequent speakers, but I think if it is shot down, then at least it serves its purpose of focusing discussion. So I'll throw out this hypothesis. Restorative justice, at least as conventionally defined, the Venn diagram, could not alone provide justice for victims of violent crimes. And I draw a very clear line. Property crimes or maybe things that we don't conventionally call crimes, delinquent acts by juveniles, maybe those should be treated differently. But when we're talking about what Nassar did to the women in the case that we've been talking about today, I will argue that restorative justice alone cannot provide justice for those victims. And let me give you a few reasons for this. One is that restorative justice, again, as conventionally defined, typically requires a forward-looking, problem-solving outlook. And that might be simply inconsistent with some victims' desires to hold a violent criminal accountable. I think we've heard many expressions of that view during Nassar's sentencing. And if we're supposed to problem solve, well, this is just some problem to be solved, I think that 100 years in prison may be the way to solve Dr. Nassar's problem. And perhaps restorative justice doesn't envision that sort of outcome. Also, restorative justice may envision a face-to-face confrontation, which has the potential to create emotional or physical risk for some victims. Now, perhaps this can be solved by making restorative justice, I know Senator Lee has been very attentive to this, an option that's available to some victims. But I do worry that some victims might be coerced into this process, even if it's viewed as entirely voluntary, or maybe stumble into the process in a situation where they're not prepared for that. It was interesting to hear Quinney talking about some of the preparatory steps that were taken in her particular case. And so I think we need to think through those implications as well. Also, I think we have to worry about, restorative justice, you want to forgive him, right? I mean, there's going to be pressure that facilitators or others might put on victims to do the right thing, which is the right thing from the point of view of some persons, but perhaps not the right thing from the point of view of victims. It may be that some victims want to forgive. We've heard interesting discussion of that this morning. But it may be the case that others do not want to forgive or are not prepared. And by the way, let's not leave the defendant out of the equation. It may be that he's not worth forgiving because he has not taken actions that he should be taken, at least at that particular point in time. But restorative justice, I think, sometimes can be create a risk that victims will be pressured into that approach. And also, if restorative justice focuses on relationships, well, that can all too easily slide into the notion, well, it was the relationship that you two had together that caused this to happen. When in fact, I think we ought to sometimes say, no, the victims had nothing to do with this sexual abuse. It was entirely the actions of the defendant that were responsible. So we need to be cautious about what's sometimes called victim blaming, and I'm afraid that in some permutations restorative justice can slide into that kind of an approach. So if we think that restorative justice, as my modest hypothesis suggests, cannot work in at least some violent crime cases, there are some implications for this. Restorative justice then sadly may have limited potential to address some of the problems that we're concerned about. And if we're going to review restorative justice as a supplement to criminal justice processes, it will be because it cannot deal with many of our criminal justice issues. And let me here throw some data on the table. Here's some data. This is from the Justice Department Bureau of Justice Statistics. We sometimes have this myth that there are lots of nonviolent people incarcerated, and this is state data, by the way, not federal data. You'll see here that 53% of all prisoners in this country are there for violent crimes. There's a big swath, about 16% are drug offenses. But if you take that green slice, only about 6% of the green slice, or 1% of the entire pie, is what I think we would all agree are nonviolent drug offenders. So there's sometimes this notion that there are a lot of low-level nonviolent drug offenders in prison. I think it is hard to maintain in face of the data. Public order crimes, those run the swath, cover the gamut of different things. Some of those are felons in possession of firearms and things like that. So, this is what we're looking at. If we want to become a little bit more local, we can go to the state of Kansas. And again, this is according to your Department of Corrections in a recent report. 70% of persons in Kansas's prisons are there for what are defined as crimes against persons, and then the rest are drug and a few others. The point being here, and Professor Pfaff has, I think, written the most detailed account of this in his recent book about the true causes of mass incarceration. Look, it's all too easy at a conference like this or a legislative session to say, oh, let's just let all these nonviolent offenders out of prison and all the problems will be solved. That's probably wishful thinking. Most of the growth in our nation's prisons has been as a result of additional inmates going into prison who've been convicted of violent offenses. Many of those violent offenses, by the way, are extremely violent. Many of them involve murder or manslaughter, and you can see the risks that are on the rest that are listed there. It's also important to understand that the data that I've just shown you are what the defendant pled to, and we know it is all too often the case that even violent offenders can work out a plea deal to some kind of nonviolent crime, given the overwork that our justice system faces. So on these cautionary notes, I'll just end here. What should we do in the face of all this? I think we should continue to strengthen crime victims' roles in our criminal justice process. We should continue giving voice to victims and listening to those voices, as Judge Aquilina did. But I think we need to be aware of the challenges and the actualities of violent victimization that will make some of those reforms more difficult to achieve.